Our speakers have been so disciplined and eloquent that we have time left for some questions. If anyone from the floor would like to ask one, the floor is open.
There'll be a quiz.
Perhaps Martin Burke, I was interested in I've been too involved this year in getting the play produced rather than actually reading part of the history. And I know Walter will probably talk about some of this, but I was sort of fascinating as to, because Marion found an ad for the book, The Catholic Question, in, was it Baltimore? And I was just wondering what else was known about this publication at that time in 1813, and why did he do what he did, and how broadly publicized was this case and Sampson's effort in it?
I'll defer to Professor Walsh in terms of the legal publicity. But if one goes through newspapers, magazines, and book publication advertisements, as Marion has, there certainly were copies of the text available at primarily Catholic booksellers in Baltimore, in Charleston, Louisville, New Orleans. All seem to be variants of the New York imprint. Generally what one does, this is stereotyping, has not been introduced yet, so what one does was simply buy the text and put a different imprint cover on it. But the people who seemed to pay most attention to it were Protestant clergy rather than the general public. And as I said in my remarks, they seem to be a lot more concerned with the Coleman section, which is much larger. Coleman's 112 pages, I think Marion counts everything at 125 pages, but it's in much smaller type than the typeface for the Sampson's record. And I could find in newspapers or magazines simply no reference to the trial qua trial, but the Coleman piece got a lot more input. Professor Walsh has pointed out, and thanks for doing the research, that there's a Dublin imprint of the Catholic Question done subsequently. That doesn't contain Coleman's brief exposition on the sacrament of penance. I guess that's irrelevant in Ireland in the 19th century. There is a Manchester, UK imprint of Coleman's section done in the 1820s, which is detached from the Sampson trial transcript. But if one is a reader, you're mostly going to see a reference to the People v. Phillips in the context of Coleman rather than the context of William Sampson.
I want to make some point about this. I wasn't going to, but it's very interesting about publicity. New York has kind of the Bible of constitutional stories, a man named Charles Zebrina Lincoln. He wrote a 5-volume history of the New York Constitution, and everybody relies on it. He was a delegate at the 1894 convention, and he compiled this massive document, which is considered quite genuine and legitimate and scholarly. And after reading the article by Professor Welsh, I went back, because he has the Constitution annotated, and he annotates everything. He's very careful about the cases, and I went back to these provisions. It's not mentioned. It's not mentioned, and it's kind of disturbing to me, because students of the New York Constitution and the should be aware of that. I mean, we rely so much on him, it's just not there. And in my treatment and other treatments, there is no mention of it. I hope I get another shot at the revising this Constitution before I die, because I certainly would do some significant revision in terms of this particular clause of this initiative, but it's not there, and he's not one to be that careless. I don't know why.
Are we allowed to ask questions of each other? So I have a question of my fellow panelists and maybe Walter. Certainly, the lay trustees are vitally important because I don't think the church or a clergyman could hold title to the physical structure of the church in 1785. Under New York law today, the Catholic Church holds title to property as a corporation sole, but that possibility didn't exist in 1785. And the question I've got is, when does it become possible for the clergy to effectively take over title to the land? I assume that's by an act that becomes possible by virtue of an act of the New York legislature. I would have a suspicion that Archbishop Hughes was terribly important because he was a very politically effective man in getting that legislation passed. But I'm wondering if any of you know, because that would be it would be that legislation that would effectively make lay trustees unnecessary and wipe out their power and transfer all power to the clergy. But does anyone know when that's enacted and what the politics of it was?
I don't know the exact date, but I suspect it was during Hughes's time. But my understanding is today, in this archdiocese at least, every parish is a corporation, and it consists of 5 people. The president is the archbishop, the vice president is the vicar general, the pastor is one of the trustees, and the other 2 trustees are lay people. So in effect, the archbishop controls 3 of the 5 votes.
As I remember, I'm trying to, I believe there's a flurry of activity that takes place both with regard to court decisions and legislation around 1850, I think, in New York. That would be, when is Hughes? He's about that time, isn't he? I mean,
He was here from 38 to 64.
And if I could just chip in here, so I think you're very much right about this bill, and it was the case that the clergy could not hold the property, and this was under New York law. And because of this, it created a legal structure where the trustees were very powerful, and they used that power. And as you heard, that caused some friction. And it has been superbly researched by John Peter Gilday, who wrote a series of superb articles on this, so it is very thoroughly documented. I don't have the specific date in my head, but I think the time when this declined is somewhere about the Hughes period that you mentioned. And if I could mention a couple of other things. First of all, both Professor Burke and Professor Gailey both mentioned the importance of the state constitution in this case, and it certainly was that. It's important to realize that Sampson did explicitly make an argument also based on the US First Amendment. And not only did he make it, but it is actually incorporated into the opinion of Judge Clinton, Mayor Clinton in the case. It's very interesting because it was exactly 20 years later that the US Supreme Court, in a case called Barron versus Baltimore, first addressed the question whether the Bill of Rights, the first 10 amendments, did apply to state action, including, for example, the First Amendment. And they said no. And it wasn't until after the adoption of the 14th Amendment, and indeed its incorporation well into the 20th century, it was really the 1940s that you begin to see the US First Amendment being applied to state action. But it's impossible to say that Phillips was wrong in this because it was decided before any of that. But the Supreme Court went in a different direction later. But it's interesting in that way. And then just a rather interesting point I'd also bring up from Professor Shelley's presentation, which is that you mentioned Ambrose Manahan. And I cannot resist sharing with you, what was the date of the time you mentioned his expulsion?
It was September 1845.
Okay, well, he made a bit of a comeback of sorts, oddly related to this case. because in South Bend, Indiana, I dropped into the Notre Dame Library, and completely unexpectedly, as I combed through the catalogs there, I saw a reference that I had never seen before, and I rooted out this beautiful book, which it's a beautifully typeset, printed and bound, annotated 1867 reprint of the Phillips case. It's beautifully annotated and done. It's a very lavish and very beautiful work. What's odd about it is that, including indeed more than Sampson's original report, so it's a true labor of love, and it includes, among other things, for example, a biography of Father Coleman, and it is called the opening volume of Manahan's American Catholic Museum. It's dated 1867, and inscribed in pencil on the flyleaf is this following note. This book was never published, and there were but 6 copies struck off, of which this is the only one, I believe, that was preserved. The author, Reverend Dr. Manahan, died just as the book was being stereotyped, and as none of his relations saw fit to pay the printer for his work, he struck off 6 copies, one of which was sent to me to see if I would purchase the plates. Not choosing to invest, the plates were melted up by the printer. So this is a printed book that was never published, and it's signed in pencil by L. Keogh in November of 1872. So it might have thrown it back into the public domain, while it is important to note it had a continuing legal jurisprudential currency, and through this period the priest penitent privilege ultimately became the rule in America. But it did disappear for a period from public view.
I wasn't aware of that. He did publish a book, a theology book, that Orestes Brownson thought very highly of. But he also said about Hughes, he was a tyrant, but with a heart.
I'm not sure if that's a happy or a tragic note to end on, but please join me in thanking the panelists.